Colegas.
Colleagues, so we'll continue our meeting. Now I am going to give the floor to His Excellency Mr. Per Olsenfrid, so that the state can give their responses to the concerns that were raised by the various members of the committee. You have the floor, sir.
Thank you, Mr. Chair, and thank you also to the distinguished members of the committee for their comments, concerns and questions that have been raised. And we truly appreciate the opportunity to further answer and be more specific on the issues that was raised during your remarks. Before I ask my colleagues to be more specific on a race of issues, I'd like to try to answer a couple of these questions on my own. The government regards the overall structures, systematic work, follow-ups and the coming strategy. Let me start by saying that the government is committed to ensuring full respect for Sweden's international obligations on human rights. And in the coming strategy for human rights, the government will present a structure for systematic work on human rights. And since this strategy is currently being prepared in the government offices, it's however premature to comment on specific proposals in the strategy. However, it will include how the government looks upon issues like follow-up on the recommendations from this and other committees. Let me assure you that also in this aspect, the role and involvement of civil society plays and will continue to play an important role in the promotion and protection and follow-up of human rights in Sweden. We have a close dialogue and look forward to structure this dialogue even more in the future. The government sees civil society as has a crucial role in this regard, not at least when it comes to writing reports on the fulfillment of Sweden's commitments to a variety of conventions. We hope to present the strategy in May or June this year. As also said in my introductory remarks, one important aspect in this coming strategy is to suggest the establishment of an independent national institution to promote and protect human rights in accordance with the Paris Principles. The government expressed in July last year that its intention to suggest that such an institution should be established in connection with an already existing public authority under the Parliament. However, since it's up to the Parliament to decide on the establishment of this independent national institution, it is the Parliament that will decide on in what way such an institution should be formed. But it's also important for the government that we have a transparent and an independent institution, and therefore not under the government but under the Parliament. On the committee member asking on counter-terrorism measures, I'd like to say that the Swedish policy is that fundamental rights and the principles of the rule of law must be ensured in all actions to combat terrorism, both nationally and internationally. The rule of law and the right of fair trial is guaranteed by several provisions in our constitution, and persons who are suspected of terrorism crimes have the same protection and rights as persons who are suspected of other crimes. There are a range of bodies that have the task of monitoring that the public authorities comply with the law in force. And regarding the national coordinator to safeguard society or the democracy against violent extremism, I would like to say that the entire work to safeguard democracy against violent extremism in Sweden proceeds from safeguarding democracy and equal value and the rights of all people. This is the platform for the preventive work against extremism and terrorism in Sweden. As I said in my introduction, to prevent and counter violent extremism, it is essential to address norms and values and attitudes that interact and contribute towards growth of and recruitment to violent extremist ideologies. radicalization of young people, etc. And this is the role of the national coordinator. Also, I'd like to address the questions on surveillance. Swedish signals intelligence is within foreign intelligence is clearly regulated. The regulation is mainly found in the Foreign Intelligence Act from 2000 and the Signals Intelligence Act from 2008, but also the Foreign Intelligence Court Act from 2009, the Act on Processing of Personal Data in the Foreign Intelligence and Development Operations of National Defense Radio Establishment, the FRA, that was mentioned by the committee member. But also the ordinance containing instructions for the Swedish Foreign Intelligence Inspectorate from 2009. The Swedish Foreign Intelligence Inspectorate is the main supervisory body concerning foreign intelligence and signals intelligence. The activities of the National Defense Radio Establishment are closely scrutinized in accordance with the decision of Parliament, Riksdagen. And Riksdagen has requested the government to once a year report a review of the signals intelligence activities that have been conducted under the Act. And these reports are submitted by the government at the end of every year. And I'd like to say that Sweden has one of the most elaborated national legislations on the signal intelligence. The Act on Signal Intelligence and other applicable laws and ordinances contain legal certainty as well as independent control mechanism to ensure the requirements for individual privacy. The legislation ensures a balance between national security and individual privacy. The Swedish legislation fully comply with Article 17 of the Convention. Also, the question regarding diplomatic assurances, my short answer is as described in our report. There is no practice in Sweden of using diplomatic guarantees. Diplomatic guarantees have only been used in one occasion, and this was in 2001, prior to the period of this seventh periodic report, and has not been used before or after this. I'd like to say something also about the work on the National Action Plan Against Racism. During the autumn of 2015, the Minister for Culture and Democracy hosted a variety of awareness-raising activities for the general public and dialogues with vulnerable groups on racism and similar forms of hostility in various locations throughout Sweden. Representatives from civil society, politicians, and officials took part in these activities. And one aim of this initiative was to strengthen the already ongoing work against racism. Another aim was to gain and gather information and recommendations for this coming National Action Plan Against Racism, which will be presented also before summer, I'd say in the month of June. The national plan will include general measures against racism, as well as measures targeting different forms of racism. As I said in my introduction remarks, different forms of racism, such as Afrophobia, anti-Semitism, anti-Ziganism, and Islamophobia. And then will also include measures to prevent and combat hate crimes. The government is contributing grants also to organizations within the civil society who are continuously working on different measures to improve democracy and prevent racism and xenophobia. Mr. Chair, there was a specific question regarding Afrophobia. And I'd like to say that since this also is a specific target of the coming action plan, I don't have too much concrete details of such a plan at this time. But I'd like to address the committee and say that the Equality Ombudsman has been assigned to raise awareness, especially against Afrophobia, during the period of 2015 and 2016. and this will be executed in dialogue with several relevant civil rights organizations, other members of civil society, and representatives of the Afro-Swedish community. The Living History Forum has been assigned to produce educational material about different types of racism and intolerance from a historical perspective and a present perspective. And the Swedish National Agency for Education is producing awareness-raising work about xenophobia and other forms of intolerance to be used in Swedish schools. And this is a task that have been assigned for the years 2014 to 2017. I'm now going to give the floor to my colleagues to answer questions that I have just not targeted here. Before that, I would also like, on behalf of my government, to thank the distinguished committee members for the condolences and remarks on our Prime Minister, Olof Palme. We appreciate this. Now, I'd like to give the floor to my colleague, Eric, from the Ministry of Culture, that will continue to address the issues raised by the committee. Thank you.
Thank you, Honourable Committee, Mr. Chair. Regarding the question on incorporation and the status of the convention within Swedish law, Sweden applies a dualistic system, which, as I'm sure the committee knows, means that in order to be applicable, international treaties must either be transformed or incorporated via a special statute into Swedish law. The most common approach in Sweden is to establish a corresponding provision in a Swedish statute. Up until now, the only convention that has been incorporated as a whole is the European Convention on Human Rights. However, as we mentioned in the opening statement, also the Convention on the Rights of the Child is in due course to be incorporated into Swedish law. And according to the principle of interpretation in conformity with the treaty, court and public authorities is obliged to interpret Swedish law to make it consistent with Sweden's convention commitments as far as is possible within the wording of the Swedish national law. And in this regard, it's also crucial that there is knowledge and awareness of human rights within the public sector. And as such, the government has taken several measures in this regard. For example, a commission to Uppsala University to develop and implement a general program of professional development on human rights. This in order to ensure that public servants are aware of international obligations. On the matter of court rulings, there has been no development since the report. There has been a mention in several court cases. However, this has only been since one of the parties has mentioned the law, the convention in their applications. And when we turn to Article 26 of the convention, the Swedish constitution sets out the obligation of the state to protect its citizens against discrimination. Furthermore, the Discrimination Act is the national instrument in protecting women and men from discrimination. Furthermore, the Penal Code contains provisions that prohibits discrimination, and in some this means that we believe that the article is applicable in Swedish law. Turning to Roma rights and the long-term strategy for Roma inclusion, there is a continuous follow-up and evaluation of the strategy. This is only the first phase, however, and this is the first phase of funding. The strategy is terminating only in 2032. Even though the final evaluation has not been presented, we can see progress after the first 4 years. The strategy's 5 pilot municipalities have set up strategies for long-term work, and also Roma mediators have been trained and employed within several areas of society. There is a final evaluation of the first 4 years of the strategy that will be presented in April of this year. Furthermore, the government has already announced that it has allocated around 6 million euros for the work for Roma inclusion in 2016 through 2019. Thank you.
Thank you, Mr. Chair, distinguished members of the committee. Thank you for raising many important issues. I will try to respond to your questions regarding a specific crime of torture and statute of limitation, access to lawyer, pre-trial detentions, so questions 8, 9A and B in the list of issues, and I will also try to answer the issues regarding the right to a trial in reasonable time and Mr. Assange. Starting with the issue of a specific crime of torture. Sweden maintain its consistently held understanding that the Convention on Torture does not, nor does any other international convention which Sweden is a party to, oblige a state party to incorporate a specific provision on torture in domestic legislation. The conventions, as well as other international instruments requirements, are fully met by Swedish rules and regulations. And as was mentioned already in Sweden's former reporting, Sweden has provided extensive information on the relevant domestic legislation, which includes various forms of assault. However, I can mention that amendments to the Penal Code in 2010 extend national jurisdiction over the crime of particularly aggravated assault under the principle of universality. Nevertheless, as mentioned in the opening statement, an inquiry was commissioned in June 2014 to consider the need for a specific provision on torture in Swedish penal law. The inquiry presented its report in September 2015, and one of its proposals is that a specific crime of torture should be introduced in Swedish law and that the statutes of limitation would not apply to the proposed specific crime. The inquiry's proposals are currently considered within the Ministry of Justice, and I can say that the formal consultations have recently been completed. It's too early to say how such a crime would be constructed in detail to describe its prerequisites, but in the inquiry's mandate, Sweden's international obligations were to be taken into account. Now, turning to the issue of access to lawyer, it is the Swedish Code of Judicial Procedure which applies in detention cases, this code does not have any limit on the number of hours which a public defense lawyer can be compensated for, though there is a special tariff per hour. The court dealing with the matter decides on the compensation, so this is an issue for the independent courts. Turning to the issue of remand periods and the use of restrictions, as mentioned, we have now taken broad action to limit remand periods and the use of restrictions and to mitigate against the isolation of persons on remand. The government intends to actively work on the results of these reviews to ensure that these goals are achieved. However, it's too early to say what final results these measures will lead to. But as mentioned, the action include new guidelines and regulations from the Swedish Prosecution Authority, which are in force since May 2015 and August 2015 respectively. And there are some signals that these guidelines and regulations have led to reduced use of restrictions in practice. However, it's yet too early to conclude any clear correlation. In addition to the Swedish Prosecution Authority's work within the framework of current legislation to reduce the use of restriction, the government has considered there to be a clear need for a broad review of the issue. For this reason, in July 2015, the government appointed an inquiry tasked with investigating what additional action should be taken to limit remand periods and the use of restrictions and to mitigate against the isolation of persons on remand. The inquiry has been given a broad mandate in order to ensure the issue is investigated comprehensively. The remit of the inquiry includes considering and, if deemed appropriate, proposing new forms of pre-trial supervision measures as an alternative to pre-trial detention, time limits for pre-trial detention and restrictions, measures that aim to reduce the use of restrictions, and measures that mitigate against the isolation of those who are in pre-trial detention. It is particularly important that the inquiry finds potential improvements for children and young people who are in pre-trial detention, and the inquiry is to publish its report no later than 23rd of August this year. Over the course of the year 2015, the government has also decided to task two authorities with assignments that are of significance to the issue of pre-trial detention, one to the Swedish Agency for Public Management and another to the Swedish National Council for Crime Prevention. Finally, it's worth mentioning that the government has already tasked the Swedish Prison and Probation Service with the implementation of a special initiative for young people over the course of the period 2013 until 2016. In order to find forms for measures that specifically target young people while also relieving their isolation, the Prison and Probation Service is implementing early interventions targeting young people in remand prisons. And finally, as regards pre-trial detentions, I can also mention that we have a very close dialogue with the CPT concerning this issue for the moment. Turning to the issue of the right to a trial in reasonable time, for some administrative cases, that is compulsory cases, the length processing time of a case is regulated by law. For other cases, the length is regulated by court practices. These regulations are often considerably shorter than those regulated in the case law of the European Court for Human Rights. And finally, turning to the issue of Mr. Assange. As noted in the Swedish government's comments to the Working Group on Arbitrary Detention, submitted on the 4th of February this year, it is for the Office of the Prosecutor and relevant courts to decide how to proceed with this case. And as explained in our core document in paragraphs 28 and 29, the authorities and the judiciary are independent from the government in their decision-making capacity in a particular case relating to the exercise of public authority vis-à-vis a private subject, or relating to the application of law. Consequently, in such cases, the government is prohibited from giving directions as to what decision the authority should arrive at in the particular case. Thank you.
Honourable Committee, Mr. Chair, I would very much like to thank you for addressing and highlighting the challenges of important questions about security and quality in healthcare, and especially in psychiatric care. I'm going to try to answer questions about the illegal detention due to lack of housing and about ECT, electroconvulsive therapy. I will start with the illegal detention due to lack of housing. According to Swedish constitution, every citizen is protected from detention and is also in other respects to be guaranteed freedom to move within the country or to leave it. These rights and freedoms can, under certain circumstances, be restricted by law. And those laws, when it comes to psychiatry, is Compulsory Mental Care Act and the Forensic Mental Care Act. And both laws contain substantive and procedural rights rules that meet the fundamental safeguards, such as requirement of predictability and possibility of control. When a patient has been under compulsive care and is ready for discharge, he is ready for, or she is ready for discharge when he or she is not any longer considered to need the care in a unit within the county council closed health care. This should always be the call of a treating physician. The chief medical officer can, in order to bring about cooperation on the coordinated care plan, call for care planning with the municipality under the Liability Act. The municipality is responsible for offering or helping the individual to get housing. And if the municipality when the municipality has received information about the discharge, they will have 30 days notice in order to plan for the patients moving out. That includes housing. And after 30 days, the municipality is obliged to pay if the person is discharged cannot leave the hospital due to lack of housing or support. And this is a final incentive in order to encourage municipalities to handle any case urgently. During those 30 days, I need to be very clear. If a person should be forced to stay in a healthcare facility during these 30 days or more, that has happened, he or she is free to leave the facility at any given time as he or she wishes, and that is very important. If either part, now we're talking about, in this case, the municipality, fails to meet the needs of the patient, the Healthcare and Social Care Inspectorate is the government agency responsible for supervising healthcare and social service, as well as supervising the processing of complaints concerning, for example, the reporting of irregularities in healthcare and social care. So they have the mandate to criticize municipalities that cannot help out with housing or support. So that is it about illegal detention due to lack of housing. Now I would like to talk about ECT. And ECT is an important question too, and the question of supplementing the Swedish patients' register with treatment performed by other professional groups has been discussed for a number of years. And the National Board of Health and Welfare proposes that the National Patient Register should be supplemented with treatments performed by professional groups other than doctors, since they conclude that only between 20 and 25% of all treatment carried out in psychiatric outpatient care is being recorded. But we do have in Sweden something called, and I think you know that, National Quality Registers. And National Quality Register contains individual-based data on problems, actions taken, and outcomes in healthcare and social care. A National Quality Register is audited and certified by National Steering Committee for Quality Registers. And at present there are 81 of them in Sweden, and one of them is on ECT. And this ECT register has been established with the support of Swedish government and the Swedish Association of Local Authorities and Regions. And in 2012, all the units in the country that provides ECT was connected to the register, and good quality of the reported data and high coverage is supported by national and regional organizations. So what we have registration is voluntary, and anyone registered can at any time request to have the data removed from the register and take part of the information concerning him or her. Today we have a coverage in these quality registers of 89.3% of all ECT treatment performed in Sweden. And the quality register cover numerous indicators such as therapeutic indication for treatment, assessment of remaining symptoms, clinical assessment, and assessment of memory impairment. And so we have a lot of data thanks to the quality register, which is important in order to enhance improvement and security and equal healthcare in Sweden. Thank you.
Mr. Chair and members of the committee, first of all, it's a pleasure to be here today and speak before the committee on behalf of the police division and the Swedish government. First of all, I wish to return to two remaining points raised by Mr. Cheney concerning statistics on in connection with the Act on Punishment for Terrorist Offences. And I've tried to compile the statistics for this, and I can say the following today. In 2006, there were 3 convictions that led to an average of 2 years imprisonment. In 2010, there were 2 convictions that led to imprisonment for 4 years. At the moment, we have 2 convictions pending appeal in the Court of Appeal in the west of Sweden. So in total we have 7 convictions, albeit 2 of them are pending appeal. I also figured out that we have 1 acquittal back in 2006 also, and we have 3 prosecutions that were turned into convictions for other types of offenses, ordinary offenses according to the criminal code. So in total I've compiled 7, 8, 11 cases in relation to the Act for Punishment for Terrorist Offences. Concerning the issue of new legislation, there will be new legislation, new criminal legislation entering into force on the 1st of April of this year. And this criminal provision covers individuals who receive training with the intention of using it for terrorist offenses, individuals who travel abroad with the intention of committing or preparing terrorist offenses, individuals who travel abroad with the intention of providing or receiving training for terrorist offenses, and individuals who finance such terrorist travels. In relation to this, it's first of all worth mentioning that we have had the problem with foreign fighters, and at present I can say that approximately 280 Swedish citizens has left Sweden for the conflict region in Syria and Iraq. It's assessed that 125 have returned and that around 40 of them have died. It seems that 25% of those leaving Sweden for this conflict region are women. And before leaving the point of terrorism, I also wish to mention that in the bill to the Parliament concerning the new legislation, the government is saying that there is a need to take a comprehensive look at the criminal law against terrorism, and that the government intends to have an assessment and evaluation of a comprehensive nature in order to assess the criminal law regulation against terrorism. Turning to Mr. Rodley, who pointed to what we say in our response in point 61, we are referring to an all-party committee of inquiry to considering whether an independent body should scrutinize the activities of both the police and Swedish Prison and Probation Service. I can say that this inquiry certainly reported in due time on the 30th of April last year. The report with the proposal is still pending because after a broad consultation we are very much in favor of consulting broadly when we are trying to set up new agencies and preparing new legislation. There's been a discussion about possible redundancy, because you heard that the Chancellor of Justice, the Justice Ombudsman, the Security and Integration Protection Commission and other entities in the administrative setup have roles to play. So there are some still remaining issues, outstanding issues, before a final decision can be taken on the basis of this inquiry. Now finally I'm turning to some serious issues, really serious issues concerning the questions, pertinent questions put forward by Monsieur de Froville. And before I answer them, I wish to make a more general comment concerning the Swedish Crime Survey, which is a yearly exercise that is intended to add to the official crime statistics and provide some qualitative assessment and insight in how the criminal justice system and how exposed individuals are to crime in Sweden. And it states that um, that the percentage with a high degree of trust for the police has increased since 2006, when the percentage was 55, to 65 in 2015. So this is a very welcome development, because trust is the capital that law enforcement works on. And we need to foster trust in society in order to perform our duties well. I also wish to point to the question concerning trust in persons suspected of offenses being treated fairly. It says that a similar percentage, 56%, have a high degree of trust in the police treating persons suspected of offenses fairly. Trust in the police in this respect has essentially been stable since the question was introduced in 2008. I would be happy to provide you with Mr. Froville with this paper if you wish. It's provided as in summary in English. Now, turning to the more detailed questions. Well, I agree with Mr. de Froville that point 64 in this report is not a miracle of clarity. I agree that it's quite confused because it mixes apples and pears to some extent. So, but the figures are correct. There is a high degree of reports and complaints directed towards the police, but few of them are leading to prosecutions. Some others of them are leading to disciplinary measures, and this is dealt with by the disciplinary board of the police. I can say that in 2014, the statistics for 15 is not ready yet, but in 2014 the disciplinary board received 115 cases, and 110 were finally decided by the board. And 4 employees were forced to leave the police service. 2 of them police officers and 2 of them civil employees. They also decided on 63 cases of disciplinary measures for misconduct in the service, and 32 employees received a warning, and 12 received a deduction in the pay. So there is indeed a disciplinary activity going as a result of the complaints delivered, but we also have the number of prosecutions, which are in this instance quite few, comparatively speaking. And again, point 64 could well have been developed and expressed in a much clearer fashion. There was a question about a day fine, what a day fine is. It's a very Swinglish expression, perhaps. But the purpose of a day fine is the same as for a progressive taxation. Let's say you make 5,000 euros a month. Then the judge, when he sentences you to a day fine, he calculates on the basis of your monthly salary. Which means that if you earn then 7,000 euros a month, you will pay more in order to have the same effect on the penalty, regardless of how much you earn. So if you don't have an income, you don't have much to pay for a fine. A few years ago, there was a person convicted for purchasing a sexual service, and as it happens, he had a monthly salary for over 100,000 euros, and the day fine was accordingly quite high. But that's the purpose of the system. Turning now to two important issues. Mr. de Froville brought up the number of deaths as a consequence of the police using a firearm. And he also brought up the issue of the use of expanding bullets. It's correct, as Mr. de Froville pointed out, that for over 25 years there's been, on average, 1 person dying as a consequence of police using a firearm. But in 2013, something happened since 4 people died as a consequence of police firearms, and in 2014 there were 3. So something happened, but this is to be seen also in relation to the fact that the police are making 1.3 million intervention each year, and each year on average again the police is firing its firearm around 30 times, out of which 15 for the purpose to hit the target. One situation is that the police is firing at a car or a vehicle in order to stop the vehicle. Sometimes persons are inclined to try to run an officer over. Now, the attention brought to this seemingly increase in deaths as a consequence of using firearms led the police, fully supported by the government, to make a very comprehensive study on the use of firearms in the line of duty. And I've been reading the summary in order to prepare for this meeting. And among the conclusions, which are very important, and we are here precisely on the same page as civil rights defenders, it's concluded that first of all that we need to have a proper review of the regulation that governs the use of firearms. And this will be a process now. This report was released only on the 1st of February this spring, this year. This will be a process started by the police service during the spring. But more importantly, there is very strong recommendations on how to train the police in facing, meeting, and working when facing people with, for instance, psychiatric disturbances, or people who are under influence of drugs and are not responding rationally or as could be expected. So it's proposed and it's developed as a remedy to this, to invest in training on this. And one other conclusion is from this report is that it's believed that with a set of measures being implemented, the number of occasions in which a firearm has been used can be decreased. Expansion bullets, finally. Yes, there are arguments for and against using expanding bullets. And as Mr. de Froville knows, this is by now the type of ammunition which is the preferred type of ammunition in also our neighboring countries. And the thing is that the main reason for using this ammunition is that it should stop immediately rather than passing through and leading to collateral damages. And it's concluded in the report that the use of this information has led to that fewer ammunitions have left the target after the hit than before, when other types of ammunition was used. So the preference is to maintain the use of this type of ammunition. Thank you.
Okay, thank you very much, Mr. Chair and distinguished members of the committee. There was a question raised regarding a shift in policy regarding asylum and migration. And that was mentioned by our State Secretary in the introductory speech. Sweden has received an unprecedented number of asylum seekers during 2015, more than 160,000. And no one can hesitate on Sweden's willingness to take responsibility for those fleeing war and conflict. However, our reception system has been stretched. healthcare, schools, municipalities, etc., have been heavily affected. And to create a respite, the government pronounced during autumn a temporary law regarding residence permits. And the proposal is now being sent out for consultation. And of course also, before a law can enter into force, it has to pass through the parliament. According to the proposal, quota refugees will continue to receive permanent residence permits. Refugees and persons eligible for subsidiary protection will be granted temporary permits. When the permits expire, they will be extended if grounds for protection still exist. There will be certain restrictions regarding the right to family reunification. However, refugees will continue to have the right to reunite with spouses, partners, and children under the age of 18. And the new law, if it comes into effect, it will only last for 3 years, so it is only a temporary measure. Then there was a question raised about expulsion of migrants to a larger extent, and also questions regarding sending back children. And there will be no shift regarding the legislation in this area. There is always an assessment carried out of each individual asylum application. And if a person is found not in need of protection and there exists no other grounds for granting a residence permit, a person should return to the country of origin. The principle of non-refoulement is always respected. And in addition, when it comes to the return of unaccompanied minors, an adequate reception in the country of origin or another country that receives the minor must always be assured prior to departure. And if we look at the statistics for 2015, there were less than 60 unaccompanied minors actually returned to the country of origin. Thank you.
Thank you. Thank you, committee, for your questions. I will turn to the issue of Sweden's reservations to the ICCPR. And as has been said, a review of this will be presented as a part of the forthcoming strategy on human rights. As this committee is aware of, Sweden has in the past said that we've had strong reasons for maintaining its current reservations to the ICCPR. And the reservations we have now is on paragraph 10.3. And our reasoning there is that keeping juvenile offenders segregated from adults is deemed to be justified, since the application of this article could lead to young offenders being put in central institutions far away from family or social services. And this is because there is very few people under that age that is being under 18 that is in custody in Sweden in this way. And we fear that this could have a negative effect on their well-being. Sweden has instead chosen to put persons under 18 in institutions specially intended for the treatment of young offenders up until the age of about 25. On Article 14, paragraph 7, we not providing the right to reopen cases where new evidence has come to light. We fear that this would undermine the credibility of the Swedish justice system, and this would also then apply to cases where such a procedure would be of detriment to the accused. On 20, first paragraph, this is because of the freedom of expression is a very strong protection in Sweden, and secondly, the effect of the provisions of free public debate must be considered, and we also find that there could be difficulties in delimiting the punishable area. On Mr. Fatala's question on the question number 4, on implementation of the committee's findings, the State Secretary has already mentioned the new strategy coming. In this, we will also touch upon the procedures, as mentioned in the report, that has been drawn up in the government offices, and we also have an intergovernmental working group in the government offices where we discuss these issues, the issues of reporting to international organizations and what to do with the reports, with the concluding observations, and so forth. And the last question there on whether when an international organization has had on exceptional grounds against granting a residence permit was the question, and that has never actually been used. So that's really all we can say right now about that. It's never been used as a way of not sending somebody back. So, and in this case of implementation, I would also like to mention, as the State Secretary said, our new goal on human rights, the government's new goal, which has been adopted by the Parliament as well, which is to ensure full respect for Sweden's international obligations of human rights. And this will form the basis upon the future systematic work on human rights. Thank you.
Thank you. I would like to shortly comment on the question about the new law that implies that all municipalities must receive new arrivals for settlements. According to the government, all municipalities should share responsibility of the receptions of immigrants. This is not something new, and this implies no shift, but until now the responsibility has been unevenly distributed among the municipalities, and placements in municipalities have not been enough. And this have been resulting in prolonging the integration process for the individuals. I would also like to add that the new act was complemented with a higher compensation to municipalities for the reception of new arrivals. Thank you.
Thank you. Turning now to the questions posed by the distinguished members on the Discrimination Act and measures against discrimination. The Swedish government is committed to the fight against all forms of discrimination, and it remains one of the key human rights objectives. The Discrimination Act of 2009 includes protection for 7 grounds of discrimination: ethnicity, which includes racial discrimination; sex, sexual orientation, religion or other belief; disability; age; and transgender identity or expression. The Act was amended on January 1st of 2015 to include inadequate accessibility for people with disabilities as a new form of discrimination. The government's disability policy is aiming at identifying and removing obstacles to full participation in society. On the matter of statistics, the statistics I can provide you with at the moment is that around 2,000 individual complaints are submitted every year, and has been so since the Equality Ombudsman was merged, and the cases mostly concern discrimination on grounds of ethnic origin, followed by sex and disability. However, we will provide you with further statistics, but those are not available to us right now. We will provide you with them tomorrow or within 48 hours after the dialogue has ended. On the Office of the Equality Ombudsman, as part of its mandate, it can investigate complaints of discrimination that violate the provisions of the Discrimination Act, and as you have very well mentioned, in doing so can represent a complainant in connection with settlements or as a last resort in courts. This merged ombudsman consists of the former ombudsman of equal opportunities, ethnic discrimination, disability, and discrimination because of sexual orientation. And the budget for this merged Equality Ombudsman was initially equivalent to the total budget of the previous 4 ombudsmen, and has increased since. In the budget for this year, the government strengthened the work to combat discrimination at national, regional and local levels, and the Equality Ombudsman has also got an increased budget of 10 million crowns per year permanently from this year. Also, local activities against discrimination in the anti-discrimination offices receives 2 million annually permanently. On the question of active measures, the government is of the opinion that rules on active measures in the Discrimination Act must be amended, and the aim is that the requirements for active measures should be extended to all grounds for discrimination, and that the rules for wage surveys and action plans for equal pay should be modified. A draft bill was sent to the Council on Legislation for scrutinizing on February 11th, and the government is now considering this within the government offices and intends to submit a bill to the Parliament imminently. Finally, turning to the development of the fight against discrimination in Sweden, an inquiry chair was appointed in January 2014 to propose how the work against discrimination can be organized and effective. This inquiry will provide suggestions to ensure good conditions for the victims of discrimination to enforce their rights. The inquiry shall also investigate if the state appropriation for activities that prevent and combat discrimination is the most effective method for preventing and combating discrimination at regional and local levels. Further, it should decide whether the county administrative boards should be given an increased responsibility for the work against discrimination. In December of last year, the terms of reference were amended to include whether a different order than the present regarding the supervision and promotion of equal treatment can help to ensure an effective work against discrimination. This includes effective sanctions. The inquiry chair shall also investigate whether, and if so, the Discrimination Act's provisions on the area which is otherwise regulated by the Education Act should be transferred to this very same Act. Furthermore, the inquiry shall analyse the section in the Discrimination Act which covers areas of society such as the police and courts to see if the changes are needed. On the ICCPR, the investigator shall, among other things, analyse and, if found necessary, propose changes against discrimination in the public sector. This since the Equality Ombudsman has announced that the protection is too narrow in this field in comparison with the ICCPR, and it is therefore part of the investigation. This part of the investigation should be completed by the 16th of December this year. And with this, I hand over to the State Secretary. Thank you.
Thank you. I would like again to thank the committee for your comments and questions and the opportunity for us to give further clarity to the issues raised. I would also like to thank the members of my delegation for bringing this clarity forward with such an engagement, and thank you for this effort. I hope that we have done this in a satisfactory way, that we have addressed the issues raised by the committee with clarity. And if not, however, if there are still outstanding issues, we're of course happy and eager to provide you with even further information. If not at this hour, then when we assemble again tomorrow, of course. With this, Mr. Chair and distinguished committee, we thank you for this opportunity.
Thank you very much. I'd like to thank the delegation for all the information that they have been providing us and for the quality of the information supplied. It's something that the committee certainly appreciates. Now, there often are follow-up questions. I'm sure my colleagues will have some follow-up questions to pose. And I already have one request for the floor. Mr. Shani, you have the floor, sir.
Thank you, Mr. President, and I join you in thanking the delegation for very comprehensive and informative set of interventions. I was particularly pleased to hear about the comprehensive review of the discrimination legislation and policies, and I would like to associate myself with some of the concerns that were raised with respect to the scope of coverage, both with respect to all other grounds, both with respect to the grounds of discrimination, because it has been put forward to us that under the existing legislation, since the Swedish statute does not have an all other status provision, such as that found both in Article 14 of the European Convention and also in our covenant in Article 26 and Article 2, the existing domestic legislation does not cover all forms of discrimination, and since the Ombudsman does not have authority to implement the European Convention Act, and since Sweden is not a party to the 12th Protocol to the European Convention, there are gaps in this area which may appertain both to status and also with respect to certain government functions which are not covered by existing legislation or even by the European Convention Act. Therefore, we have one proposal that we have made would be to consider the incorporation of relevant parts of the covenant that could actually supplement this gap, but you can of course find some other ways to address this. And I was also pleased about the concern with regard to access, because my colleagues have made the point about the Ombudsman. We also understand that there are discrimination bureaus that are addressing some of these issues, but they too are underfunded, and therefore something needs to be done about perhaps expanding legal aid criteria so that victims of discrimination would be able to bring cases. I would appreciate some clarifications from the delegation as to whether the criminal prohibition on discrimination, which is currently relatively narrow, whether there are thoughts of revising, looking into that, for instance, with respect to discrimination on the basis of disability, which is something that currently the criminal provisions do not encompass under, but I would appreciate the state parties' responses to this. Another discrimination issue which we did discuss and I wanted to flag is the issue of Roma who are EU citizens and are present in Sweden on the basis of temporary stay permits. Though I understand that in practice these permits are being renewed upon every re-entry into the country. So the question is whether, with respect to these EU citizens who, for all practical terms, are living in Sweden, what is the state parties thinking about? What is their status? What is their access to what extent would their children be entitled to access the education system? To what extent they will be able to access social services? Because it is our understanding that currently they are somewhat left hanging without a real status, although they may be present for significant times in Sweden. I'm not sure I received answers to my data mining questions, so if tomorrow the delegation could provide us with information about the scope, what is the permissible scope of data mining under the Act, I would be grateful. And I wanted to, my colleague Mr. Muhumuza mentioned the Assange case, and I acknowledge the responses that we have received. Perhaps I should indicate that we are not taking a position on that as a committee on whether the interpretation that was provided by the working group also reflects the committee's approach with respect to the interpretation of the covenant. And of course, I personally don't wish to belittle the severity of the charges and the Swedish state interest in pursuing this, but I think there is an issue of principle here that needs to be addressed, and I think the response about separation of branches is not fully satisfactory, and that is what safeguards are in place in extradition cases of that nature when a person is being requested for extradition on the basis of a prosecutorial decision before charges have been filed and without court supervision. So the question is whether liberty interest in this particular configuration of extradition request, whether liberty interest are sufficiently factored in. And this is a broader question, which Assange perhaps is just one example of this legal configuration issue. As you know, the UK has changed its legislation on extradition, especially because it was uncomfortable about issuing an extradition warrant on the basis of a domestic procedure with limited safeguards, and it would be interesting to hear the delegation's response to the more institutional aspect of this question. Thank you.
Muy bien,
Thank you very much. I have two further speakers who have asked for the floor, but we have just 1 minute left to go. So maybe it would be better if we start tomorrow with our colleagues so that we don't force them to speak in just 30 seconds. I don't think that's relevant. So if that is okay, we will suspend here. And tomorrow I have Sir Nigel and Mr. Olivier de Fauville on my list so that they speak before we give the floor back to the delegation.
muy constructivo el diálogo que hemos tenido.
Thank you very much. It's been a very constructive dialogue. I hope you will rest this evening. Tomorrow will also be an arduous day, and I'd like to wish everyone a good evening. Thank you.